Josh, reporting by ProPublica has led to calls for Chief Justice Roberts to open an investigation. Then you got Playbook writing this week based on your reporting. Roberts technically doesn't have any disciplinary powers over his colleagues. Walk us through why that is.
Well, Alicia, sometimes I compare the Chief Justice's job. While it sounds like a very high-profile, powerful job, we're used to seeing him swear in the President of the United States, and in my lifetime, at least on a few occasions, seen him preside over impeachment trials in the Senate. There's really nowhere in the law or in the Constitution that says the Chief Justice can basically tell any other justice what to do about who he should hire as his staff, or necessarily about what he should do with regard to recusing from cases or ethics issues. And so generally, Chief Justices have operated by powers of persuasion, but it also means that, especially on ethics policies around the court, it often seems like you really need a 9-justice consensus in order to move forward with any sort of reform, or at least that seems to have been the tradition over the past few decades. I guess sort of this question, which you just answered about unable or unwilling, seems particularly relevant because you've seen the public opinion on the Supreme Court. It's low. Chief Justice Roberts says he wants to be a defender of the court's credibility. Is credibility possible with Justice Thomas seated on the court, given the controversies that he's involved in, and particularly if there is no inquiry into it? Well, I think that's the problem, Alicia. If there were seen as some sort of independent inquiry, or even maybe a non-independent inquiry, then people would at least perhaps have some faith that somebody is looking into the matter. But historically, what we've seen here is that the way this works is Congress usually does not have the desire or the willpower to actually investigate these things themselves, and prefers to ask the Chief Justice or the justice involved to explain further or investigate. And often those sorts of requests don't go anywhere. There only seems to be a response when the justice who is being accused chooses to respond. And sometimes he'll respond. There were questions about Justice Alito allegedly having been involved in the leak of an outcome of a case a decade or so ago. And he issued a statement. And then when Congress wrote to the Chief Justice kind of paraphrased that statement back in a letter to Congress. So that's how it's worked in the past. But if the accused justice is recalcitrant or doesn't want to respond, it's just not immediately clear what mechanism there is, except, of course, for sort of the nuclear option here, which is impeachment. I've got about 30 seconds left, but I do want to ask you about this other headline, because today the Washington Post is reporting that in 2017, Texas federal judge Matthew Kacsmaryk submitted an article to a Texas law review that was criticizing Obama-era protections for transgender people and those seeking abortions. And then, according to emails verified by the Post, he later removes his name from the article during his judicial review. I need to note NBC News has not yet verified that reporting. Just real quick, Josh, just how unusual is that? Well, if this occurred while the nominee was before the Senate, it's a little surprising to me that they would remove their name from an article and try to allegedly obscure this. I have heard in other situations of nominees who are judges maybe delaying the reporting of a decision in a case. I think that may have happened, in fact, allegedly with, believe it or not, Clarence Thomas when he was being named from the D.C. Circuit to the Supreme Court. But the specific circumstances you're talking about sound rather unusual to me.